Good morning and welcome. My name is Vincent Rougeau, and I am the president of the Association of American Law Schools and dean of the Boston College Law School. I am so very pleased to open today's proceedings for the AALS Conference on Rebuilding Democracy. As was noted in our conference materials, there's a widespread sense shared by those across the political spectrum that crucial aspects of our democracy need reform. Although there is surely disagreement over the nature of the problems and the best solutions, few would deny that our democracy can be improved. The goal of this conference is to bring together law professors, lawyers, and others with expertise to consider how to rebuild democracy and strengthen the rule of law. The conference itself will take place over 2 days and will focus on 4 themes: the presidency, the electoral process, race and voting rights, and improving presidential elections. Today, the focus of all 4 panels is on the presidency. Tomorrow, the focus on the panels will be on voting, race, and elections. I want to begin by thanking Bob Bauer and Jack Goldsmith for their book, After Trump, Reconstructing the Presidency, which was the inspiration for this conference. The conference will open with a discussion of the book in which the authors will participate. And we're so very grateful that they've agreed to do this. Next, I'd like to thank our co-hosts, Patricia Rifo, president of the ABA, and Kelly Testi, president of the LSAC. LSAC is providing all of the technical support for the conference today and more. I wish to thank AALS Executive Director, Judy Areen, whose early ideas and vision were the inspiration for this event, along with the book, and all of my colleagues on the AALS Executive Committee for agreeing to host this mid-year conference. Thanks as well to the wonderful AALS staff for all of their hard work behind the scenes to support this and all of our programming. The AALS has held many conferences devoted to improving legal education, and this is the first time we're focused on what the Legal Academy can do to improve the health of democracy and support the rule of law. Thanks as well to all of our very talented moderators and speakers who are participating over the 2 days of this conference. We're all looking forward to your presentations on these important topics. To all of you watching the conference, whether on Zoom or live stream, thank you for joining us. We hope you will gain insights and ideas on how we can strengthen the health of our democracy, just as vaccines are now improving the public health of our nation. And now it's my very great pleasure to introduce my colleague, Darby Dickerson, immediate past president of the AALS and dean, University of Illinois at Chicago John Marshall Law School, who will be moderating the first panel. Darby?
Thank you, Vince, and thanks to everyone who's joining us here today. It is my honor to moderate today's first session titled Reconstructing the Presidency. Our 2 panelists, as Vince mentioned, are Bob Bauer and Jack Goldsmith, authors of After Trump, Reconstructing the Presidency, in which they provide a comprehensive roadmap with concrete proposals for reforming the presidency. Before I introduce Bob and Jack, I want to encourage faculty members inside the Zoom room to post questions that you may have for our panelists in the chat box. I'll monitor the chat and plan to weave in some of the audience questions. Bob Bauer served as White House counsel under Barack Obama. He also served as general counsel to the Democratic National Committee and as GC for the 2008 Obama-Biden campaign. He is a professor of practice, a distinguished scholar in residence at NYU Law, where he teaches a presidential power seminar and co-directs the Legislative and Regulatory Process Clinic. In 2013, he was appointed co-chair of the Presidential Commission on Election Administration, and in 2021, he was appointed by President Biden as co-chair of the Presidential Commission on the Supreme Court of the United States. Jack Goldsmith is the Learned Hand Professor of Law at Harvard Law School, a senior fellow at the Hoover Institution, and co-founder of Lawfare. Before joining Harvard Law, he was Assistant Attorney General leading the Office of Legal Counsel in 2003 and 2004, and also served as special counsel to the Department of Defense during 2002 and 2003. He also has served as a professor at the University of Chicago Law School and at the University of Virginia Law School. Thank you both for joining us, and thank you for writing such an outstanding book for us to discuss in this forum. Jack, let me start with you. Can you give us some background on why you wrote this book? I understand that the two of you originally started to write a book about the White House Counsel, but ended up with After Trump.
Yes, first of all, let me say thank you very much for having us on. We're honored to be here and very grateful to be discussing our book. Bob and I got to know one another when he left the Obama administration. He was teaching a class at NYU, and I think a precursor of the class he's teaching now, and I went to that, and we became friendly. We had an academic exchange and about lawyering for the president, and in the course of that, we thought it might be a good idea to write a book about the White House Counsel's office, where Bob used to work in the Obama administration, and with which I used to deal a lot when I was in the Bush administration. There's no great book on the White House Counsel. In the course of a day-long meeting about that book, trying to sketch that book out, I think this was about 2 years ago, we kept coming back to what was going on today in the Trump administration, and we kept talking about the 1970s reforms of the presidency, how important and consequential they were, and how they'd come up short in the Trump administration. And we just kept coming back to all the ways that that was the case. And over the course of the day, we had decided not to write the White House Counsel book, but rather to write a broader book about reforming the presidency, because we believed and hoped that once Trump left the scene, that there would be a discussion, a kind of comprehensive discussion about accountability and regulation of the presidency, akin to the ones that happened in the 1970s. So we wrote this book basically as a background and guide and to those issues, and as a comprehensive suggestion of a reform program.
Thank you. Bob, for those who might not have had a chance yet to read the book, can you give us an overview of how the book is organized?
Certainly. We have 3 parts within which are various topics for reform. And we open with a discussion of why we think reform now is an appropriate, indeed urgent topic for conversation. We talk about how we're going to address both legal reforms and reforms that reinforce failing norms, and norms is an important part of this discussion, to be sure. We talk about the importance of looking at reforms in the most bipartisan or nonpartisan way possible by adopting a variant of the golden rule, which is that you would support a reform even if it could somehow handicap the discretion of the president you favor, allied with your party. And we then have in each chapter, and this is the organization we follow throughout the book, both a discussion of the history of a particular issue, presidential war powers or conflict of interest regulation of the executive, a history up to the Trump era, then a discussion of the Trump era and the very specific set of issues that the Trump presidency raised. And then in the third part of each chapter, we address the reforms that we want to put on the table for general discussion.
You come from different philosophies and background, but you achieve consensus on most issues you address in the book. Can you tell us a little bit about how you selected the topics to include in the book and how you actually wrote the book? Did you divvy up the topics and one of you wrote on one chapter and another one, then another chapter? Did you both simultaneously write chapters?
I'll answer that. We didn't know that day we agreed to write the book. We didn't know what the topics would be, and we didn't know if we'd be able to reach consensus. We came to the list, haphazardly. Some things were obvious, like tax disclosure reform and conflict of interest reform and election interference reform. Other things about special counsel and some of the intricacies of the Justice Department we weren't as sure about. We weren't sure what to include about. There are a lot of separation of powers issues between Congress and the president. So we talked about what we thought were the most salient and most important to reform. We came up with a rough list and we changed the list as we wrote. We basically divided up the chapters. So each of us would take a crack more or less at one chapter first, more or less in accordance with our relative expertise, but then we would swap the chapters and each go over it thoroughly. We had tons of back and forth. And we changed our minds along the way, and we basically reached consensus on every issue except one.
And tell us what that one is.
The one issue Bob and I disagreed about, and it's more of a disagreement in emphasis in the end, and we explained this in the book, is on the fate of Donald Trump after he's left office and whether and under what circumstances he should be subject to criminal investigation and criminal prosecution. I'll let Bob speak for himself, but basically his view, and it's a view that I'm very sympathetic to, is that if Trump has in fact committed crimes or crimes that warrant investigation, they should be investigated and followed through, because otherwise you basically give the president of the United States a free pass, since under the current OLC rules, he's not subject to investigation, not subject to indictment while president. If he also gets a pass after he leaves the presidency, he's in effect immune to the rule of law. And that's a very powerful argument with which I agree. I agree with that basic argument. My point is that in the current context, given the current facts, it's not obvious that Trump has committed a crime that's prosecutable. I think any prosecution of him based on everything we know right now would be extremely difficult. And I think pragmatically, the costs of doing so in terms of distraction to the Biden administration, pumping up Trump, and moreover, potentially costs to the rule of law, since I think Trump would ultimately be vindicated. I think that the costs outweigh the benefits. That's a judgment call. I'm not opposed to, it's a judgment call based on my perception of the facts, which could prove to be different. And I'm also not opposed to the investigations going on for his pre-presidential and even post-presidential actions. It's just the actions while in office, if they're investigated, I fear also, in addition to the other costs, it would just become a norm. And we've already seen tit for tat investigations across administrations a lot in the last few years. And I fear it would become a norm that would not be worth the cost.
Bob, do you want to add on to that?
No, Jack has really represented the basis of what I think is correct to say is a disagreement and emphasis. I tend to be pretty critical of the OLC opinion that provides that the president is immune from prosecution while in office. And I very much worry about the whiplash effect, that then there's a norm that protects the president after he leaves office. I probably am also less confident that the president would be, former President Trump would be vindicated. I just don't know whether that's the case at all. And I think what I do share is certainly the appreciation this all has to be done the right way. It has to be done in such a way that it does not appear that the party in opposition that got control of the executive branch then began looking for, if you will, matters on which to prosecute the former president. But with that caveat, if you will, I do think the fundamental principle that Jack articulated, that the president does have to be subject to the rule of law, and that if he's immunized or she's immunized from prosecution while in office, really leaves us with the conclusion that the chips should fall where they may once they leave office.
Thank you. Bob, let me stay with you. You articulated what I think is one of the guiding principles as you used to write the book, and that was the golden rule. Did you have any others?
We should emphasize, both of us came to the book with one, I think, shared understanding, and that is that we do believe in a strong presidency. We have a section of the introduction, and we talk about the importance of retaining the strength of the presidency as an institution, but drawing on language that Arthur Schlesinger used in his magisterial imperial presidency, his book, The Imperial Presidency. We also believe the strengths of the presidency have to be contained within a system in which the presidency is constitutionally accountable. And so we look at a number of questions throughout the entire book about the potential unintended consequences of a reform that could hobble what we think the executive has to have, which has, in the appropriate areas, the ability to act effectively and energetically where we have come to expect and rely upon the importance of executive leadership.
I'm going to ask each of you to address this next question, and it's a little bit of a top 2, 3, or 4 list. We're a little past 100 days into the Biden administration. Which of the reforms in your book do you think have the most chance of success? And what are the primary obstacles for implementing any of your reforms at this time?
Bob, you want to go first with that?
Look, I'm happy to go first. There is no question that in the congressional session we currently have, in the middle of a pandemic and under conditions of severe economic dislocation, an entire reform program aimed at the presidency is not plausible, and it's not going to happen. However, we have seen bits and pieces of a reform program emerging that could have bipartisan support. The prospects for moving the reform program are obviously improved, where the President of the United States would support such reforms. We acknowledge in the book that if Donald Trump had won a second term, any kind of reform program along the lines we were discussing would be dead on arrival. That's not the case right now. We have a Democratic Congress and a Democratic president, and the president is committed to reform in some of these areas. And there are a number that we can pick out that we think ought to stand some prospects for a success. I will pick in no particular order, only because the House has already acted on it in part. That is, the Judiciary Committee has reported out a bill that includes, among other things, proposals that Jack and I have made for curbing abuses of the pardon power. Let me just stress as we start talking through these issues, it's what's important is to start somewhere. That is to say, to get the ball rolling. Because if we go an entire presidency, if you will, with no executive reform post-Trump, and remember, the book makes the case that much of what we've seen in Trump, that Trump has done, that creates significant questions about indifference to the law or indifference to the norms, was built on a long history of problems with the presidency. That is to say, some of these issues have roots, clear roots, that were helpful to Trump in challenging our understanding of how the president should operate in so many ways. And so there's a history here that we just have to come to terms with, as well as what Trump has indicated to us or shown us are the fissures, the weaknesses in the constraints and norms that we thought actually would govern the presidency. So we have to get a start. We have to get a start. And almost anywhere that you could start, whether it's mandatory disclosure of tax returns, financial conflict of interest, regulation, internal regulation of the Department of Justice to accomplish the goal of depoliticization, curbing the pardon power, any step forward, I think, is extremely important in the coming year and a half.
Jack?
Yeah, I don't have much to add to that. I'll just want to underscore something Bob said, and this is really an unusually favorable moment for reform like this, given the basic political context of the last few decades. You have the object of reform would be a Democrat president, and that's the president who's going to be feeling the bite of reform, who basically supports these. We think that's an unusual circumstance. And now is the time, and not 2 years from now, because if Donald Trump declares, for example, that he's going to run for president in a year or two, that's going to make reform much harder, because there's a window now when at least some of these issues aren't necessarily about Trump. They can be more broadly couched. Again, Biden would be the president who's feeling the ostensible bite of them. And so there is a moment now, and it's an unusual moment of political possibility, but whether it can be made high enough on the agenda and whether and where it starts is very hard to know. We're working on that. I'll just say one other thing. A lot of our reforms don't require congressional implementation. A lot of our reforms, I would say about half, are ones that can and need to be implemented by the executive branch, especially in the Department of Justice. There is not a question of, there's no political hurdle. It's just a question of whether Attorney General Garland and President Biden want to adopt certain provisions, certain regulations and guidance that would, in our view, sort of deepen some important norms that weren't clear enough during the Trump administration.
Let's stay with the DOJ. Why don't you share with us some of the reforms that could be implemented by the DOJ? And I know that you also wrote about restoring the reputation and independence of the DOJ. So if you'd like to comment on that as well, this would be the time to do that.
Sure. So there's not a silver bullet here. We have 5 chapters and 30 proposals, and none of the DOJ reforms by themselves are enough. None of them is a silver bullet. I'll just give you a flavor. But first of all, let me say some people are skeptical about the role of norms after what's happened in the last 4 years. And there's good reason to be. And a lot of our proposals are about taking things that are norms and translating them into legally enforceable statutes. But some issues should and can only and should be implemented within the Justice Department, having to do with Article 2 and the president's control over the executive branch. I'll just give you a flavor. And I also want to say, before I tell you some of our proposals, that the norms actually worked better than people give them credit for in the last 4 years. They were damaged, no doubt, and Trump disregarded them. But even the Department of Justice, in many circumstances, didn't go along with Trump and followed the norms of independence, however grudgingly and whatever the context was. The Mueller report, Volume 2, is full of instances of Trump's close subordinates in the White House and the Justice Department not carrying out his wishes to fire Mueller. that was all about the independence norms and the obstruction of justice norms, if not law, that people abided by. And there were lots of examples of that. So with that background, here are just a few examples, and they're just narrow slices, and there are more than these. But one is, we think it's very important for, there's a norm in the Justice Department against political bias, and there's a hard line to draw between political bias, which is disallowed, and taking into account politics and making law enforcement decisions, which is allowed. And we propose that this kind of diffuse norm actually be written down and trained upon so that everybody knows about it and it's front and center rather than kind of in the air. That's one. Another is that it wasn't clear. The current regulations do not extend the Justice Department prohibition on commenting on ongoing investigations to the Attorney General. And of course, Attorney General Bauer violated that norm incessantly during the Durham investigation. There's no guarantee that the next Attorney General would abide by that norm, but it would raise the stakes. Other examples are the 60-day rule, which this is not really a Trump issue, but this happened when Comey, right before the election in 2016. It turns out that the 60-day rule about not commenting on ongoing elections isn't written down anywhere. The Inspector General said this is not really, and Comey took advantage of that when deciding to do what he did. There are others, but those are three. We have lots of proposals for the special counsel and how to alter the special counsel regulations, again, in fine-grained ways. The main idea is to take norms that were, everybody thought were norms that didn't really have a kind of written basis, make them clear and train people on them and elevate them.
And Bob, you mentioned that Congress, some of the committees have already reported out on the pardons and self-pardons issue. Could you update us on that and tell us some of your ideas about reforming the issue of the president's ability to grant pardons and potentially a self-pardon?
Yes. So in our chapter, first of all, we take on the general assumption, one that was popular with Donald Trump, who repeated it, that the pardon power is absolute. And that is an overstatement. It is certainly a very, very broad power. But even, for example, Attorney General Bauer agreed that presidents can violate the criminal laws by, for example, selling a pardon or using a pardon in a way that is intended to tamper with evidence before a court and obstruct justice. So there's no question there are limits on the uses that the president may make of the pardon power. It may not affect the pardonee, but it will affect the president as the issuer of the pardon and potentially bring him or her within the scope of the criminal laws. So we recommend an amendment of the law to make it very clear that the bribery statute in particular does allow for the prosecution of the president for the use of the pardon power to accomplish a bribe. And we also believe that Congress should take a stand on self-pardons and make it very clear that in Congress's view, a president cannot pardon himself or herself. Now, the latter point is controversial with scholars. There's some disagreement on this point, but there's no reason why Congress cannot take a stand. I think our view is that Congress can take that stand and that it could influence the court and make a difference. And this is an example, again, of taking steps that are reasonable steps that are grounded in a fair understanding of the law, in our view, the correct understanding of the law, and that could make a difference in signaling that some of these extreme claims of presidential authority that lead to abuse, presidential overreach, can be reined in. I cannot tell you exactly where matters stand right now in the House. I know the Judiciary Committee did report out these particular provisions as part of a broader set of presidential accountability reforms. And Jack and I consulted with them on that because they expressed an interest in how we had set these reforms out in our book. Where that stands and how it's going to progress on the congressional calendar, I couldn't tell you.
Thanks. Let's stay on Congress for a moment. You're critical in your book about the lack of congressional oversight and accountability. So can you just give us an overview of the issues you see and some potential solutions to the issue of congressional ineffectiveness?
So let me just start off by saying that we make very clear up front in the book that there are many problems in the American political legal landscape. that, if improved, might make the presidency a better institution. And at the top of the list, so electoral reform, which we're going to be discussing in other panels, is crucial to electing virtuous presidents with integrity and with democratic support. And you could also think about reforming Congress. Congress has been a fairly feckless institution for a long time now. We don't, in the book, we just focus on the presidency, and we take the other institutions as we find them. We take the Supreme Court precedents as we find them. We take Congress's diminished state as we find it. There's no doubt that the lack of congressional engagement and the lack of congressional engagement as an institution vis-a-vis the institution of the presidency, as opposed to breaking down into party affiliations and supporting the presidency or not on that basis. There's no doubt that that has contributed to problems in the presidency, and we don't have a direct solution for that. Our proposals do, however, many of the proposals operate such that, on the assumption that Congress is not a great institution for accountability, we don't make heroic assumptions about Congress's ongoing oversight responsibilities. And we design the reforms hoping for a one-shot implementation by Congress, for example, on war powers or on congressional subpoenas, on all sorts of other issues, emergency powers, hoping that a one-shot reform can change the system in a way that can improve it without the assumption of continuing ongoing congressional close supervision, because that just doesn't happen on a regular enough basis.
Bob mentioned that where we are with the presidency today, we didn't get there just with President Trump. We've seen overstepping and maybe even some abuses in other administrations. One area that I know people have concerns about is the increasing use of executive orders to get things done. Can you talk to us about your position on the use of executive orders?
Bob, you want me to take that?
Sure.
So this is an issue that we didn't take head on in the book, and because it really is not an issue about executive orders. It's an issue about the executive and the administrative state and the relationship between congressional delegation and executive authority, and how and under what circumstances the president can rely on Congress in implementing administrative regulations to carry out the government. This is a broad issue. It transcends administrations. President Obama was criticized for being very aggressive, for his aggressive use of executive orders, as was President Bush before him, as was President Trump in different respects. We don't take this on. This is a larger issue about the delegation doctrine, about Congress regulating more specifically, about whether the president should have a very broad conception of the take care power. We address those types of issues in discrete contexts that we thought were the most salient for reform: war powers, emergency powers, vacancies reform, and the like. But we don't take on the whole general idea of the relationship between Congress and the presidency. It's just too broad. We would have to write several books.
I know that you started out writing a book about the White House Counsel's office, and you included a chapter about OLC and the White House Counsel in the book. Can you give us a bit of a summary and your positions on that?
Yes, I think we came to this, if I'm not mistaken, Jack, I think we came to this sort of when we were well advanced in the book and decided to write a chapter on this. And as I will start by saying, I was White House counsel to President Obama, and it's the best job I ever had or will ever hope to have. But I began to have some thoughts, and Jack and I discussed some critical thoughts about the White House counsel's office and the role it currently plays in the legal advisory structure that the president relies upon. The office has always been controversial. This is an example, again, where the introduction to a chapter that puts everything in historical context before we arrive at the Trump era, we think is very important to understanding the reasons for the reform that we put forward. And the conclusion that we reach is that the White House counsel's office as a presence in the West Wing ought to be downsized. The White House counsel, it can be there, of course, on location. The president needs that sort of at the elbow legal advice with maybe 2 or 3 deputies, but that the better part of the office ought to be removed and located back in the Department of Justice. The White House is a very political environment. It's an intense communications and political environment, indeed, as it should be. It is not the best environment in which lawyers can operate. After all, they wind up becoming sort of more senior aides to the president than perhaps being always able to establish the sort of detachment that I think we would want lawyers to have as they give the president their best independent legal advice. That isn't to say, I should hasten to add, that lawyers in the executive branch don't have an obligation to help the president look for legal alternatives to effectuate the policy on which the president campaigned and made commitments to the American public. But there is a fundamental question of integrity of the legal advisory structure, and we think it's better served by having the department restored to what was, for the better part of our history, its traditional role as the principal legal advisor to the president. And it still does do that through the Office of Legal Counsel, but we think it can absorb more of that responsibility that has passed over time to a White House counsel's office, which is actually now, a small to medium-sized law firm nested in the West Wing and in the old executive office building.
Jack, anything to add to that?
Yes, I'll just add one thing. I mean, a lot of people, when they hear that we're proposing to move legal advice from the White House to the OLC to depoliticize it, say, what are you talking about? Everybody thinks the Office of Legal Counsel is this political legal group. And as I've written many times before, there's no doubt that the Office of Legal Counsel in the Justice Department takes a particular stance on executive power and on the whole views the law in a way favorable to executive power, at least compared to courts within its jurisprudence. But the point is a relative one. And there's no doubt that being down the road in the Justice Department in a culture that is quite different than the one that prevails in the White House, that is staffed by career attorneys, including senior career attorneys that weigh in on a lot of these issues who've been there for decades. It's just a move towards relative independence, towards relative detachment. We're not naive enough to think that OLC is going to operate like a court. It doesn't do that, and it shouldn't do that. But it's just a move to take a lot of these legal issues out of the political hothouse environment of the White House into the relatively less hot Justice Department.
While we're on this topic, what surprised each of you when you took your respective posts? Bob, you as White House counsel, and Jack, you at the Office of Legal Counsel.
Everything about the job surprised me. What the government was doing in secret, the difficult decisions about the job. I was extremely naive about the scale of responsibilities and the difficulty of the decision making.
For my part, I wouldn't say I was surprised by this, but it's different experiencing it than hearing about it.
Right.
That in the White House, you have a very small number of people, relatively speaking, in a tiny piece of real estate. Former Press Secretary Bob Gibbs said it was like working in a submarine and working extremely long hours and extremely long weeks, very frequently to the brink of exhaustion. Not an ideal way for government policy and important decisions to be made. It puts a lot of responsibility on a relatively small number of people in a system like the one that we have, where the presidency plays such a central role, and in the executive branch itself, even that is to say, when you consider, how much devolves onto the cabinet, for example, or agencies, and how much of territory the president claims for himself or herself. So I just thought the organizational and other challenges of working in that environment and trying to be effective for the president were really significant.
We've had a few people want to know if you were writing an epilogue for the book, what topics or insights might you include, and would you have altered any of your views? And I think specifically people are interested if you would have addressed the lawful transfer of power and the insurrection at the Capitol.
Jack, Jack and I've discussed it. We've discussed what reforms could be targeted at that. We actually do want to be part of that conversation. There is no question that there are problems that nobody really foresaw within the legal structure that currently governs the transition, the lawful transition of power. Everything from the General Services Administrator's discretion in deciding who is the apparent winner of the election, and then authorizing the release of additional and in fact full funding for the transition. These are huge issues, and they just need to be tackled. And I just want to say, I'll seize it to make the same editorial point I made at the beginning. Granted that we have major problems facing the country right now that urgently require being addressed, public health emergency and economic problems of a very high order affecting millions and millions of Americans. But it would really be very dangerous to leave these matters unattended after the experience of the last 4 years. And the example you just gave is an example of something that it would be negligent beyond belief to leave unaddressed at this point. We've seen how dangerous this can be. You know, why would we just wait until 2024 to see whether it could happen again?
Can I just add one thing to that? I agree with all of that. And it just underscores the importance of reform now, because every month that goes by, it's going to become politically more difficult. At the same time that it becomes more necessary, potentially more necessary. But I just want to add, we're talking about all sorts of legal reforms for the presidency, and we have 440 pages worth, and we left a lot on the table. But at the end of the day, and this is especially true in the transition, I mean, you can fix the transition process and impose legal reforms there. And there are other things you could do to maybe tighten up the laws in various ways. At the end of the day, law can't solve everything. I mean, if you have a president who is as determined as President Trump was to act in anti-democratic ways and unpatriotic ways in challenging an election and in doing everything he could to destroy or discredit the institutions around that, there's only so much that law can do. And I still think it's remarkable, even as precarious as it was, it's remarkable that the institutions held during that period at the state level, at the federal level, and the judiciary, with some notable exceptions in the Congress. So those were all norms. That was not law that was required. It was law-infused norms, but those were hugely important. Not sure how you buck those up any more than you did, but in the end, there's nothing you can do. Even if a president wants to attack those things, law can only do so much. So it's really important who we elect as president of the United States. That's the obvious conclusion.
Well, it appears that former President Trump may be planning to run again in 2024. If none of your proposed reforms are enacted, what would you be most concerned about during a second Trump administration?
My list would be a very long one. I'm not sure how to pick from it.
I would just say, this is something, the point we make in the book. Every single thing we talk about, let me just add that that some of the things like war powers that we proposed reforms for, Trump was maybe not as bad as his predecessors as pushing the legal envelope, and certainly no worse. But on most of these issues, Trump was different in kind from his predecessors, even if there were precursors to what he was doing. The danger is that Trump would be much worse on every issue we discuss in the book if he wins election again. And because he learned over the course of his presidency, he was actually fairly incompetent at wielding executive power and getting his way. He could have been much worse if he were better organized, more dutiful, understood governance better. I think every one of these issues are going to be worse. He knows where the bodies are. He knows how to manipulate the bureaucracy. They were just getting going at the end about trying to destroy the civil service. Every one of the issues that we talk about in the book, where we want to kind of put up barriers and establish laws and norms to do better next time, they face an even greater onslaught in a second Trump presidency. And that's not fear mongering. It seems obviously that will happen. And the likelihood of him winning, I don't know, but now is the only time to take steps against it.
I'm going to throw out some questions from our audience members. The first one is, could you comment on HR 1 S1 for the People Act?
I'm happy to take that. As you know, that's an 800-page bill that addresses some of the issues we're talking about here. It addresses a whole host of others. The voting rights, campaign finance reform, independent redistricting, and there is ethics reform, including reform of the Office of Government Ethics to provide protection for the head of the Office of Government Ethics. It provides for a change in the enforcement structure for the enforcement of the campaign finance laws. So it's an omnibus reform bill, and it's not focused specifically on the types of reforms that we're talking about, although in some respects, some of the reform proposals there overlap with them. The
next question is, you say you both support a strong presidency, But does the immense powers of the modern presidency put too much pressure on the electoral process? Parliamentary systems don't have Bush v. Gore or a January 6th insurrection. Presidential elections are uniquely difficult to make free and fair, especially when competitive, and all the more so as the power at stake increases. If we want to solve the problems we confront in our electoral system, do we need more fundamental shrinkage of presidential powers?
Bob, you're the election expert. I'm going to let you take that one.
I would tend to, it's an interesting question. I have to say, I would tend to separate the two out. I don't think, yes, there's no question that the more that's at stake in a presidential election, the more that we will see very aggressive competition. And as we've seen in the last election, the dangerous possibility, in this case, fueled by Donald Trump, that the loser won't accept the outcome, that the outcome is so viewed as so existential by both sides. They will not only fight tooth and nail to win, but they won't accept the loss when they should be facing it. But I don't believe, particularly given the history of the strong presidency in the 20th century, that I don't believe that we have to think of the answer to the problems with the electoral process as lying in some way in weakening the presidency. I think we do clearly want to subject the presidency, and that's the premise of the book, to some critical constraints. But I think the form of the electoral process is an enterprise that could be undertaken quite separately, and I think it should be undertaken without necessarily going about making a fundamental change in the kind of strong presidency that I think ultimately the country depends upon.
Can I just add one thing real fast, please? I mean, it's not clear what it means to fundamentally weaken the presidency in modern times. It's not clear if it's even possible. I mean, we propose, I think probably our proposal that is most, that would most shrink presidential power is a narrowing of the war powers. And that's an area where presidents for many, many decades with congressional acquiescence have been engaging in ever, in my view, more tenuous justifications for the unilateral use of force. That is an area where Bob and I would shrink presidential discretion down to areas where we think are more legitimately the president's sole domain. But other than that, it's just not clear what it means to shrink the presidency unless you have a more engaged Congress, for example. I mean, governance has to get done. The society is enormously complex. There's an enormous bureaucracy. Some people fantasize about shrinking the bureaucracy down to nothing, about getting rid of regulations, but modern society is hugely complicated. And the president is necessarily, and this has been the arc of presidential power over 200 and some odd years, has grown because of the energy and the focus and the hierarchical status and the executive tool. So, I mean, Bob and I talk, qualitatively without specifying what we mean in a powerful presidency. And some people talk about shrinking down the presidency and making it smaller. But I'm not even sure that it's possible to do that. I mean, first of all, you would need a very, very, very robust Congress standing up to the president to do that, which is simply not going to happen. And second, you'd have to come up with an answer to the question of how governance is going to work. These are large, large questions, and I don't purport to have answers, but I just want to say that it's not even clear in 2021 what a significantly shrunken presidency looks like.
Jack, let's stay on the War Powers Act. Talk to us about some of the reforms that you would like to see in that area.
Sure. We have three basic baskets, I'll say four basic baskets. One is, and the simplest, and we hope something that is achievable, is there are some really extreme and unnecessary kind of dicta-like war powers opinions from the early Bush administration and the Office of Legal Counsel, which haven't been relied on, that we think OLC should withdraw, along with a lot of other early Bush administration opinions that have already been withdrawn. Second, and next easiest, is AUMF reform of the Forever War. There's a lot of consensus on this about getting rid of the 2002 AUMF, getting rid of the 1991 AUMF, and changing the 2001 AUMF, the one I'm speaking in shorthand. The 2001 AUMF is the one after 9/11 that has been the legal basis for the war for 20 years now. There's broad consensus that needs to be refocused on the war as it is now. We propose doing that. We propose mechanisms to bring Congress more in the loop on what counts as an associative force, where the war is going, who we're fighting against. These are issues that shouldn't be in the shadows, that should be in the public, and Congress should weigh in on them. We propose, and this is a sticking point for many, a sunset clause to force Congress to weigh in every 3 or 4 years about whether the war should continue and on what circumstances. So there's the AUMF reform second. Third, more ambitiously and much harder to achieve, is broader reform of the presidency about these unilateral presidential powers beyond the AUMF that I was talking about a second ago. This involves reforming the War Powers Resolution and rethinking the relationship between Congress and President on war powers. That is, there's much more talk about that now. Congress is more on board for that now than it used to be, but that's very hard to achieve, and that's something the executive branch would probably oppose. And fourth and finally, we have some proposals to deal with the president's really extraordinarily and quite scary unilateral power over nuclear weapons, which we kind of went along with in this country before the Trump presidency, but Trump's, casual threats about using his big button led a lot of people to rethink whether that system is a good one. And we propose some very targeted reforms, legal reforms, to make clear when the president can and can't use the nuclear weapon, along the lines exactly of America's longtime nuclear posture and policy that we think can help prevent crazy, irrational uses of nuclear weapons. So it's a 4-part strategy.
Back to some audience questions. What about the norm of legitimacy of elections and access to the ballot? Do the changes in voting access and in census shifts bear on this issue?
Well, if I understand the correct, the only thing I can say in response to that question, it's an important question. It's a broad one. We do have in this country, a fundamental battle right now over what constitutes meaningful access to the franchise. And one party has turned out to make it something of a cause célèbre. They're both disputing the outcome of the last election and looking to reshape the laws to protect against the fraud that there is no evidence to support that they believe occurred in the last election. And this is going to continue to be a really serious issue facing the country. To the extent that it involves the presidency, it is clear that Donald Trump is making this a loyalty test within his own party. This whole question of the electoral process and whether he was cheated out of the election and what needs to be done to prevent him from being cheated out of the next election if he runs. And I think people are aware that the House is about to oust the head of the caucus, Congresswoman Lynn Cheney from Wyoming, because she has refused to accept the fraud claims that Trump has been making against the election, and does not support, for example, what the state of Arizona has begun to do, which is to conduct some kind of ersatz audit, even though the election results have been by law repeatedly affirmed in Arizona. They're now hauling ballots off into a convention center under the guidance of an organization that has been retained for this purpose, improbably called the Cyber Ninjas. So the situation is sort of veering out of control on that point, and it is a very, very serious problem. But this falls under the category of what we do to address the voting rights, what could be turned out to be a voting rights crisis in this country.
So earlier we talked about what your priorities would be. We have a question in the chat about congressional priorities. So how would you recommend that Congress prioritize the reforms you propose? Would you focus on the ones that can get bipartisan support and could clear the Senate? Which ones would those be, and how would you rank them?
So we've talked about this a lot, and on some days we have different answers. I would put the most important congressional reforms, I think Bob agrees with me on this, but he can tell me whether he does after I say it, into two baskets. One is there is long-standing bipartisan support for things like tax disclosure and conflict of interest rules applying to the president, even though they don't by law. And maybe the conflict of interest rules are too hard, but on tax disclosure, and that cluster of issues related to presidents and finances and potential corruption and appearance of corruption, we think that's an important issue on which there's potentially bipartisan support, because there has been at least before Trump. Another very important set of issues we think that Congress should prioritize, and I would sorry, there are three. The second is the pardon issue that Bob discussed, which is a very easy fix. It's a 5 or 6 line statute. It would both bring law to bear on those tricky situations and pardons, but also norms around the law that would make everyone think twice before giving pardons that could potentially be viewed as a bribe or an exchange of some sort. And then the third and related thing are the obstruction of justice proposals that we have. This is a hugely important issue. It remains unclear in the law. People take strong positions on this, but it is unclear in the law. This is even apparent in the Mueller report. If you read the report carefully, it's very unclear the extent to which the current obstruction of justice statute applies to the president and when. And that is a situation we think is fraught that allows Trump to do a lot of what he did. And we don't think that issue should be, and different administrations may take different views on that in the absence of congressional reform. We don't think that's something that should be, about which there should be ambiguity. We think Congress should make very clear in 3 circumstances, very tightly defined, that the president can be subject to criminal obstruction of justice for involving his family, involving an election, and involving himself. And so those, I think, are some of the congressional reforms. I think that those 3 or 2 or 3 clusters, depending on how you count, we think are the most important. Did I get it right, Bob?
Yes.
Next audience question. Does international law have any role to play in the rule of law applicable to the president?
So I guess I'm the international law expert here. Is that a normative question or a descriptive question?
The person said, thinking about the torture memos and war powers, as well as other foreign policy issues.
Yes. So yes, international law obviously is relevant here. We don't talk a lot about international law in our book, although our war powers proposals are designed on the war powers resolution, in which we basically propose that the president be limited to using military force in an array of situations that come under the umbrella of self-defense and not in other broader national interest or humanitarian intervention contexts. Our proposals would bring presidential war powers, if accepted, back towards probably the standard assumption of what international, I didn't say it would meet it, but towards the standard assumption of what international law allows. The torture issue is a perfect example of where the country, this was bipartisan legislation in 2005 that closed all the loopholes and said that was unacceptable because of our international obligations and because it was immoral. So that was an example where international law influenced domestic legislation to push back on a president. I have to say that in the war powers area, the United States has been extremely opportunistic in its understanding of its international obligations, especially under the UN Charter. Again, we would push back war powers more in the direction of the Charter, but whether this will happen and whether the president will really be constrained remains obviously to be seen.
Another audience member asked, can Congress effectively protect prosecutorial independence and the independence of the FCC and FEC in light of the court's embrace of unitary executive theory? Aren't those 3 entities potentially powerful tools to subdue democracy?
You said FCC, I apologize, FCC.
FCC and FEC.
Yes. Well, HR 1, the sponsors of HR 1 certainly think that the independence of the Federal Election Commission, just to take one example that I'm familiar with, ought to be strengthened. And the theory there, and the bill has provisions to this effect, is to prevent one party from deadlocking the agency and preventing enforcement. At the moment, the Federal Election Commission is split by law between the 2 parties. An independent theoretically could serve, but the long and short of it is that no more than 3 members of the 6-member commission can be affiliated with the same political party. However, what that means is that a party that is dedicated to blocking enforcement can do so. It may be blocking enforcement for reasons that it thinks are completely legitimate, but it's still able to basically bring the commission on major issues to a halt. So the notion there is to turn it into an odd number agency, so that that possibility is at least mitigated, if not completely eliminated, and then also to provide the staff with some additional authority to operate without commissioner approval to engage in certain investigative activity. So yes, I mean, there are reform proposals to this effect, and they're intended to allow independent agencies to function more independently and outside immediate presidential control.
One final question, then I'll ask you each to make some final comments or share some final thoughts. Since we have some law students joining us today and we're legal educators, based on your experience as teachers, what are the major matters that law students misunderstand about the limits of the presidency?
I'll take a crack starting off with that. If you just read the front page of the New York Times and read the cases and the case books, and you would think oftentimes that the presidency is a lawless institution. And it's just not true. I mean, even in times when we see opinions that seem to be permissive, those are, drops in the water, and it's not typical. So much, every aspect of executive branch action is governed by law. There are tens of thousands of lawyers who on a daily basis are saying, yes, no, here's how you do it. The executive branch is legally very constrained, which is not to say that it's perfectly constrained or adequately constrained. But for example, when you read OLC opinions that say yes, and they seem, oh my gosh, they're ruling again in favor of the president, you don't see the scores of OLC opinions that say, no, you can't do that, because the opinion just never got written. That happens all the time. That happens all the time throughout the executive branch. I'm neither naive nor romantic about it. I've seen it in its full ugliness and glory, but it's still the case that the executive branch is a deeply legally regulated entity. It has its own jurisprudence. It has its own way of operating. It's often parallel to the courts. It's a legal system largely unto itself, but it's a real legal system and a constraining one.
We have about 2 minutes left. So if each of you would like to share a final thought or two, that would be wonderful.
I'm happy to lead off. First of all, thank you very much for having us. I really enjoyed it, and really appreciate your excellent questions and the questions from the audience. I'll just come back to something that I said before, and that is, anyone who is concerned about what the Trump presidency exposed in the way of weaknesses on constraints of the presidency, even those who, like Jack and I, believe that the presidency has to be a strong but constitutionally accountable president, the presidency has to be strong but constitutionally accountable, has to be concerned if we develop a case of remarkably quick amnesia about what the last 4 years has exposed and do nothing. And so, Jack and I will continue to speak out on this issue. We are in conversations with others, including on the Hill, about moving an agenda forward. And as I said, at this point, even targeted reform that lays down the general principle that the reform program has to begin somewhere, but it will begin, is critically important.
I agree with Bob. I don't have anything to add to that. Now is the time to do it. And if we don't do it now, we'll surely regret it later, whether it's in the next presidency or the one after that.
Jack and Bob, thank you for being with us this morning and answering all of our questions. And thank you for such an excellent book. To the audience members, we're going to take about a 15-minute break, and the next panel will start at 12:15 Eastern Time. Please join us then. Thank you.